All right, peace and blessings. It's Tuesday, March the 26th, the year 2019, and I'm going to go through two documents in this particular video. One of them is titled Hoch's Answer to the Bar Complaint, and the second one is titled Rebuttal by Charles to Hoch's Answer to the Bar Complaint. So we're going to go through Hoch's document, and then we're going to go through Charles's response. Now, let me also say that Charles told me that when Albert J. Hoch Jr. rested his case, Charles immediately got very upset because there was no introduction of forensic expert witnesses on the computer evidence. And Albert J. Hoch put his hand on Charles's shoulder and said, "Sit down and shut up and take it up on appeal." Now, we know that lawyers prefer that clients take plea deals because that way the lawyer doesn't have to do any work. But Charles did not take a plea deal, and now he's sat nearly 7 years in prison as an innocent man, and he's surrounded by a bunch of evil, wicked lawyers, and we know the Bible calls out the one profession by name, woe to you lawyers. And so let's get started reading this, and I pray that once you've educated yourself about Charles Dyer, that you'll write him a letter and you'll ask what you can do to help this innocent man. But page 1, this document from Albert J. Hoch is 38 pages, and the document from Charles is 19 pages, and we're going to work our way through. It's at the top, it's got Hoch and Associates letterhead with his phone number and address. It looks like Albert J. Hoch Jr.'s associate is Ali William Khalili. It's dated May the 24th, 2013. It's sent to Miss Lorraine D. Faribault, the first Assistant General Counsel, the Oklahoma Bar Association. It's got their address. It says it was received on June the 6th, 2013. And then the subject is Complaint by the Dyer Clan. Starts off with, this is from Albert Hoch. I'm just going to call him Hoch from now on. Well, let's call him Albert. From Albert. Dear Miss Faribault, the purpose of this letter is to respond to the claims made by Mr. Dyer and his mother. Paragraph 1. At the outset, Mr. Dyer is not pro se on his appeal. The Oklahoma Indigent Defense System represents Mr. Dyer on his appeal. I filed a NOIA. The trial court found that Mr. Dyer was now indigent and appointed the OIDS to represent him. Okay, this is Charles's response to paragraph 1. But before I read it, he has a response to each paragraph, and we are going to read that, but let's read the introduction before we get into each paragraph. So this is, and again, as I read Charles's letter, he has to write this in pencil from a prison cell, right? And so some of it can be hard to read. Also, it's scanned, and there's bleed over from the opposite page, from the other side of the page. So if I can't read it, I strongly recommend you download the document and you try your best to read it. But I'm going to do my best. Dear Miss Wabbs, I think it's W-A-B-S, or it could be Wallos, W-A-L-O-S, I don't know. I have received Mr. Hoch's response and your request. After reading Mr. Hoch's response, I can only assume that my grievance was unclear because Mr. Hoch focused on slandering me with attacks that were misstated or complete fabrications. If my grievance was that unclear, I apologize sincerely. My initial grievance was filed because Mr. Hoch scrubbed as in quotes, all evidence concerning a hard drive from my evidence box before it was transferred to my appellate attorney. To respond to your request, I'll need to refer to this evidence, so I'll explain what it contains in a following paragraph. Due to Mr. Hoch's unwillingness to, due to Mr. Hoch's willingness to lie to protect himself, I am forced to withhold certain information regarding current issues that Mr. Hoch may have to testify to in the future, as these issues Mr. Hoch raises are absolutely irrelevant to this grievance. I hope this isn't seen as a refusal to cooperate with your investigation. My initial grievance is centered around 5 issues concerning a single piece of evidence. Number 1, Mr. Hoch specifically told me that he was going to call forensic computer experts to present the evidence in question, yet failed to do so and did not discuss this with me. Number 2, Mr. Hoch told me that he would introduce the hard drive evidence, yet failed to do so. 3, Mr. Hoch told me that he would introduce an OSBI report on this hard drive, yet failed to do so. Number 4, Mr. Hoch removed the defense copy of this hard drive from the evidence box before it was transferred to Indigent Defense Attorney OIDS. 5, Mr. Hoch removed the OSBI forensic computer report data disk from the evidence box before it was transferred to OIDS. 6, Mr. Hoch removed the OSBI forensic written report from the evidence box before it was transferred to OIDS. All right. I have sent some of this evidence to you. If I rescind any, I apologize. I wish to label it to clarify for you. Forensic computer expert Marvin Dutton was not called. Bar number 1, witness number 16. OSBI agent Donald Raines is not on any witness list. He and Marvin Dutton and forensic examinations of my wife's hard drive, bar number 1, exhibit 11, Agent Raines' examination was done after my first trial and produced a data disk. Copy can be provided upon request, as well as a written report, bar number 2. Information contained on the hard drive. A. The hard drive contains exculpatory evidence that proves my wife's computer, which I had no access to in over a year, was used to do internet searches concerning sexual abuse and custody, bar number 3, getting parental rights back, and Oklahoma parental rights, bar number 2 and page 8. These were done up to 9 days prior to my wife's claim that she learned of sexual abuse of our daughter, bar number 3 and bar number 2, page 11. It proves that the computer was used to view pornography during the exact time frame the searches were made, bar number 2, page 11. My daughter had a forensic interview where she described sexual acts on January the 12th. The report clearly shows pornographic movies were viewed 4 times over an 8-hour period just 1 day prior to this interview. I think it says 45%. It's really hard to read. 45% of all pornographic website accesses were done on this day, bar number 2, page 5, to link my wife to these views. My wife sent my girlfriend, Amanda Monsov, an email laughing at us and wishing me luck because I would need it. On January the 11th, bar number 1, exhibit 4, Valerie's computer was used to search Amanda Monsov on this day within minutes of pornography being viewed, bar number 2, pages number 11 and 5. Additionally, pornographic pictures were downloaded, bar number 2, page 4. Response to Mr. Hoch. Let me just say that again. The paragraph that we just read, information contained on hard drive, it proves that 9 days prior to the wife going to the police and reporting sexual abuse of the daughter, that Valerie's computer was used to download pornographic images and also doing searches of Oklahoma parental rights and also sending vindictive messages to Charles's new girlfriend. That's incredibly important for the jury to hear. Response to Mr. Hoch. I had no intention to digress from the professional issues at hand and turn this into a back and forth slander of character. I am disgusted by Mr. Hoch's lies and diversions from the issue in his reply. I do not wish to reply to these issues that serve no other purpose than to assassinate my character. However, you requested that I respond to any areas of agreement or disagreement I may have. Therefore, I am obligated to do so. For simplification, I provided a copy of Mr. Hoch's reply, numbered by paragraph. I will address each paragraph with numbered paragraphs of my own that correspond. All right, this is where we're going to go into Hoch's paragraph number, and then we're going to go into Charles Dyer's response. So paragraph number 1, let's reread it from Mr. Hoch. At the outset, Mr. Dyer is not pro se on his appeal. The Oklahoma Indigent Defense System represents Mr. Dyer on his appeal. I filed a NOIA. The trial court found that Mr. Dyer was now indigent and appointed the OIDS to represent him. Mr. Dyer responds, Mr. Hoch begins by saying that I'm not pro se. I agree. Never did I say I was. So I don't understand why this is brought up. My grievance states I wrote a pro se appeal and sent it to my attorney to give him ideas. Robert Jackson of OIDS, witness A, will confirm that Mr. Hoch obviously misread what I wrote and is confused. Okay, let's go to paragraph 2 from Mr. Hoch, Albert Hoch. The evidence that Miss Dyer refers to being scrubbed involves two separate groups of items. The first group, which includes the hard drive that they complain about, was picked up from my office by Mr. Dyer's mother and sister with his approval immediately after the trial, before the OIDS was appointed to represent Mr. Dyer on his appeal. While they were complaining about me, the judge, the jury, and the verdict, and asserting that they were going to hire appellate counsel. The second set of items included the remainder of my files and exhibits, which was picked up from my office by the OIDS after they were appointed, and which included everything else. Nothing was scrubbed from my files. If Mr. Dyer and his family failed to provide the information to OIDS in a timely manner, that was a deliberate decision on their part. Charles's response. Mr. Hoch is confused about the evidence. The FBI acquired an external hard drive of mine without a warrant, permission, or reason. It had projects I was working on, my criminal case evidence, and personal information on it. I authorized Mr. Hoch to obtain it from Agent Western and give it to my family. I did not authorize anything to be taken from my evidence box, especially bar number 1, Exhibit 11, because they already had a copy of it. Mr. Hoch then states that the evidence box contained everything else when given to OIDS. Witness A will say differently, I presume. Finally, Mr. Hoch says it was my family's responsibility to provide evidence to OIDS. Why is it their responsibility and not my attorney's? He had the evidence in the evidence box. My family didn't have the box. I included is an affidavit from my previous attorney acknowledging receipt of the evidence. Mr. Hoch removed bar number 4. A stranger off the street had the same access and right to my evidence as anyone in my family. I was the client, not them. Okay, paragraph number 3 from Albert Hoch. In addition, a little history will be instructive. Mr. Dyer was charged with the offenses of child sexual abuse and knowingly concealing stolen property, firearms. Charles Dyer writes, I agree. Paragraph 4, the trial history. In Dyer's first trial, the jury reached a verdict of guilty and a sentence recommendation of 25 years to serve in the Oklahoma Department of Corrections. As the jury was entering the courtroom to have the verdict delivered, one of the jurors changed their mind, causing a mistrial. The juror later contacted the Stevens County District Court and requested that the verdict be imposed, but was advised by the court that a mistrial had already been declared. Charles's response, Mr. Hoch appears to have more knowledge than I. After 8 hours of deliberation, one juror was browbeat into saying guilty and then refused to say guilty. This is my knowledge of events. Paragraph number 5. The weekend before his second trial was to begin, Mr. Dyer's trailer home caught fire while Mr. Dyer was drinking and having sex with the secretary from his attorney's office. Mr. Dyer fled the jurisdiction of the court in what became a highly publicized case wherein Mr. Dyer later surrendered himself to the Federal Bureau of Investigation and was returned to the Stevens County for prosecution and remanded to jail without bond. Charles Dyer's response. My house was burned by arson 3 days before trial. 2 secretaries from my law firm asked if I would allow them to treat me for a night out before trial. I was not out drinking, as I was the designated driver, nor did I have sex with them. I did, however, have sushi and a good conversation. That is as ridiculously irrelevant to this grievance as Mr. Hoch's asinine statement. I did flee the jurisdiction. My wife's brother was seen by law enforcement with a gun at the courthouse. That would be Valerie's brother. During the first trial, her father, Valerie's father, pointed a gun at my girlfriend and I, and was convicted. My house was burned to the ground by arson, and I was told that the FBI agents were seen burning it. And the court denied a 1-week continuance, even though I owned no clothes to go to court in. I wrote a letter to my attorney, Judge, I believe it's Enos, E-N-O-S maybe, and Channel 4 News, maybe it's Channel 8 News, it's hard to read, and Channel something News, explaining that I was in fear of my life and leaving. I also stated that I would be back within 90 days unless I were dead. This email is included, bar number 5. All right. So let's go to paragraph number 6 by Albert Hoch. The Dyer family then contacted me in the hope that I could either resolve Mr. Dyer's cases without a trial or would be more successful than the original trial counsel. At the time they contacted me, I was already committed to several jury trials through the Oklahoma Indigent Defense System, both as a contractor and as conflict counsel. I advised them that if I took the case, I would need to have at least one continuance from the trial date, which was set at the time they retained me. They still hired me. Charles Dyer's response: I can't reply to Mr. Hoch being hired after stating he was overtasked. This is the first I've heard of. Paragraph 7, Albert Hoch. The trial court denied our motion for a change of venue, which was made before Mr. Dyer's second and third trials in Stevens County. Multiple newspaper and television stories were published in the area concerning the original charge. The flight to avoid prosecution, the multi-state manhunt, and in addition, members of various and sundry militia clans became involved through the media, including the internet. Charles Dyer's response: I generally agree, and many political groups were discussing FBI involvement in a state case, not just militia clans. Paragraph 8, Albert Hoch. During Mr. Dyer's second trial, information came to the attention of the Office of the District Attorney, who then advised counsel for the defense in Mr. Dyer's case, and another case that was being tried in a separate courtroom in the Stevens County Courthouse. The information involved a questionnaire mailing that had inadvertently gone to members of the current jury pool. Once again, the court reluctantly granted a mistrial. Charles Dyer responds: I generally agree. I was reluctant as well, but Hoch said he would be negligent to advise me against mistrial. Deputy Powell, Stevens County Sheriff, can confirm me discussing this with him. Paragraph 9, Albert Hoch. The trial court denied our motions to dismiss and applications for writ of prohibition on double jeopardy grounds after the second mistrial. Charles Dyer responds: I agree. Paragraph 10, Albert Hoch. I was able to negotiate a plea bargain offer with the Office of District Attorney that involved a sentence recommendation of 2.5 years to serve with the ODOC, credit for time served, and a period of probation on count 1 and a dismissal on count 2. You can confirm the plea bargain with the Office of the District Attorney. Mr. Dyer chose to involve his mother and sister in a discussion of the plea bargain, who both demanded that he not take the plea bargain and proceed to a jury trial. Mr. Dyer chose to follow their advice instead of mine, and now all three of them are complaining about the consequences of their decision. Charles Dyer's response: I was offered a 2.5-year plea bargain, yes. No one demanded that I take the plea bargain, and Mr. Hoch has absolutely no way of knowing what was discussed as he was not present. 3 affidavits can be produced, other than my own, to confirm this. I proceeded to trial of my own free will, and because I refused to admit to something I didn't do, Mr. Hoch never advised me to take a plea agreement. He agreed there was plenty of evidence to support my defense and show the lies concerning disclosure and police reports 5 days later. I never knew the plea agreement was 2.5 years until told in the judge's chambers. I asked a few questions and then refused. Transcripts of this are on record at the Stevens County Courthouse. I am not complaining about the consequences of my decision because if granted a new trial, I will refuse any plea bargain offered. I am complaining about Mr. Hoch lying and not presenting evidence and then removing it from my evidence box so it wouldn't be brought up on appeal. Paragraph 11. By Albert Hoch. The next jury trial was completed to verdict. Any alleged errors by the prosecutor's judge or me are on appeal to the Oklahoma Court of Criminal Appeals. Charles Dyer's response: I agree that propositions chosen by OIDS counsel are on appeal. Paragraph 12, Albert Hoch. Evidentiary decisions. The alleged victim testified in the trial and identified Mr. Dyer as the individual who had molested her. Since she was related to Mr. Dyer, there was no issues regarding identity. During direct examination and cross-examination, she did not waver in her testimony regarding the criminal acts committed by Mr. Dyer. Her testimony was consistent with her testimony during the first trial. Her testimony was consistent with her reports to her mother, law enforcement personnel, and a forensic examiner. Paragraph 12, Charles Dyer's response. The victim's testimony is not only contradicted by multiple witnesses, it is contradictory to her mother's testimony and is inconsistent and unclear as to what sexual abuse happened or when. The state forensic examiner, Jessica Taylor, even stated the victim was unclear and Miss Taylor is unsure of what abuse may have happened. This is a direct reflection of how clueless Mr. Hoch was throughout the entire trial. His dates and facts were incorrect multiple times, and he allowed lies and misstatements to be told uncorrected on several occasions. As an example, Jessica Taylor testified that the victim described specifics about my penis in the video interview, which was a complete lie. Let me read that again. As an example, Jessica Taylor testified that the victim described specifics about my penis in the video interview, which was a complete lie. But Mr. Hoch never objected, corrected, or had the prosecutor correct this, even upon my demands. Mr. Hoch seemed confused in regards to previous testimony from past trials, as well as testimony given during trials he participated in. Paragraph 13. Albert Hoch. The physical evidence was consistent with the testimony of the minor child. Among the complaints received by you concerning the hard disk drive from the computer were complaints concerning possible impact on the credibility of the ex-wife. However, none of the proposed evidence explained the minor child's torn hymen, physical testimony that the injuries were consistent with the molestation, nor the minor child's vivid descriptions of the criminal acts. Paragraph 13, Charles Dyer's response. The proposed evidence does in fact explain the vivid descriptions of the criminal acts as previously explained in paragraph A. It is not shocking that Mr. Hoch is unaware of this evidence, as he made minimal effort to become familiar with the case and no effort to discuss the evidence with me. Anytime I spoke of evidence such as this, he replied with acknowledgments such as, "We'll get that in there." And Mr. Hoch's personal views of the physical evidence was a stark contrast to what he wrote in his reply. Before and during trial, he never made these comments. He adamantly agreed that the physical evidence in the doctor's own testimony was not even definitive that sexual abuse happened, let alone that I was the author if it had. The mother claims to have seen physical damage, yet waited 5 days to report it and 10 days to seek a medical exam. Mr. Hoch now changes his stance because he considers this as a personal feud now, which is blatantly apparent in his baseless and irrelevant personal attacks throughout his reply. If he would have expressed these views before trial, he would not have been retained and would not have been my attorney at trial. As I read this, the one thought that comes to my mind is all you have to know about Albert Hoch is that he is a lawyer. You know, how do you know that lawyers are lying? When they're moving their lips. Okay, paragraph number 14. The trial court overruled the motion to strike and motion in limine filed by the defense regarding Mr. Dyer's ex-wife, and she was permitted to testify. The trial court overruled the defense objections to a forensic examiner and her examination, and the examiner was permitted to testify, and the examination was played for the jury. All of these issues are now before the Oklahoma Court of Criminal Appeals. All right, let's read Charles Dyer's response to paragraph 14. I agree. That's what Charles got to say to that. Okay, paragraph 15. Albert Hoch. With regards to witnesses and evidence that the Dyer family believes should have been used during the final jury trial, once again, they did not tell the rest of the story. After the first trial, flight to avoid prosecution, subsequent arrest, and incarceration pending trial, Mr. Dyer and his family decided that they should discuss every detail of his case, including all witnesses and any potential exculpatory evidence on the telephone from the jail. Mr. Dyer ensured the admissibility of all these calls. If any issue discussed in them came up during the trial, by acknowledging that they were being recorded, by ending his conversations with "fuck you, Jason Hicks." Although Mr. Hicks did not participate in the trial of Mr. Dyer, Mr. Hicks is the district attorney for that jurisdiction. Okay. Response by Charles Dyer to paragraph 15. I did indeed end jail conversations with "fuck you, Jason Hicks" multiple times. Mr. Hoch presents no evidence or even specifics of what he is talking about. I challenge him to do so. And as far as my hatred toward Jason Hicks, I have ended hundreds of calls with the phrase "fuck you, Jason Hicks" before Mr. Hoch was even my attorney and before my first trial. Doing so has never allowed otherwise unallowed evidence to be presented. I challenge Mr. Hoch to explain this, as he never took the time to explain it before. As far as speaking about the case on the phone, I asked Mr. Hoch to allow me to see and hear numerous pieces of evidence every time I saw him, and every time he claimed he forgot to bring them. Still to this day, I haven't had access to a single thing I requested, which included multiple recorded conversations, multiple pictures, and access to the FBI data disk information. If my family tried to inform me of goings-on, I'm sure I didn't stop them if Mr. Hoch didn't tell me not to talk about it. Let me read that again. If my family tried to inform me of goings-on, I'm sure I didn't stop them if Mr. Hoch didn't tell me not to talk about it. With Mr. Hoch's conduct, I felt I was entering trial completely blind. Mr. Hoch also assured me that he would go over questions I may be asked by he or the prosecutor, but he never had time on a single visit to the jail. That's a typical lawyer right there. Paragraph 16, Albert Hoch. The conduct of the Dyer family ensured that the office of the district attorney was aware of what the individual witnesses would say, which allowed, let me read that again. The conduct of the Dyer family ensured that the office of the district attorney was aware of what the individual witnesses would say, which allowed them to investigate the past witnesses and confirm that they would not say what the Dyer family claimed, and to prepare additional cross-examination in order to impeach anyone who did agree to testify. In conversations with these individuals, I confirmed that they would not testify to matters in the manner claimed by the Dyer family, or would be susceptible to the additional impeachment evidence which the Office of the District Attorney provided pursuant to the discovery and Brady motions which he had filed. Okay, Charles Dyer's response, paragraph 16. Charles Dyer, this paragraph confuses me. He claims that my family ensured that the DA was made aware of what witnesses would say, which allowed the DA to investigate witnesses, and this is where I'm confused, confirmed they would not say what my family claimed? Does my family's comments alter the truth? If a witness is to testify to something, what does others' assumptions of the testimony have to do with anything? If my family was incorrect on their assumptions, did this alter witnesses' testimony? This paragraph makes no sense to me, and this isn't a subject Mr. Hoch ever breached to me. However, if I am to believe his reply in full, I can't read the word, in full, there are many things he should have discussed with me and utterly failed to do so. I challenge Mr. Hoch to present specifics and not be so vague. Paragraph 17, Albert Hoch. I chose not to call some witnesses who had testified in the first trial, but who could now be impeached, and some individuals who had advised me that the Dyer family was not being candid with me about what they would say if they were called. This decision was a direct result of the conduct of the Dyer family, which rendered these individuals useless or worse in the jury trial. Paragraph 17, Charles Dyer's response. Mr. Hoch failed to call upwards of 6 witnesses that testified at the first trial. I have no clue of what witnesses could be impeached or what the Dyer family wasn't candid about, as once again, this is the first I've heard of it. If previously used witnesses were lying about something, was that not important for the defendant to know? I challenge Mr. Hoch to present specifics. Paragraph 18, Albert Hoch. In addition, I chose not to call additional individuals or open up certain topics during cross-examination because of the potential prejudice of their testimony. For example, the Dyer family now complains about the decisions I made not to open the door with Mr. Dyer's girlfriend about telephone calls and conversations involving interviews with the FBI and investigators from the Office of the District Attorney concerning allegations that Mr. Dyer had molested her daughter. Okay, that's paragraph 18, right? Yep. So Charles Dyer's response to paragraph 18. I'm unsure what door with my girlfriend could be opened. No interview was ever given with the FBI concerning additional molestation. One interview was given, not by law enforcement, and it was confirmed that no sexual abuse had occurred. Once again, I challenge Mr. Hoch to present evidence, as this is the first I've heard of it. Paragraph 19 by Albert Hoch. Cross-examination of Mr. Dyer's ex-wife revealed to the jury her drug use, infidelity, threats to get Mr. Dyer, and other issues including possible motives for her to get the minor child to lie. However, the physical evidence was impossible to overcome. Charles Dyer's response to paragraph 19. Mr. Hoch's lack of awareness that I do not have an ex-wife is indicative of his knowledge of this case. Mr. Hoch only showed a fraction of lies Mr. Hoch only showed a fraction of lies told by Valerie Dyer, my current wife, and to say the physical evidence was impossible to overcome is absolutely preposterous, as it was overcome at the first trial by David Hammond, and he gives a phone number. What is impossible is for a defendant to receive a fair trial when an attorney fails to share case information with him, lies about what information will be presented, fails to allow access to evidence supposedly against him, fails to allow a defendant any decision-making capacity in his own case, and fails to prepare his client. Paragraph number 20. Albert Hoch. Mr. Dyer's mother also wanted me to elicit testimony about the alleged victim being in a tent Let me read that again. Mr. Dyer's mother also wanted me to elicit testimony about the alleged victim being in a tent with Mr. Dyer and the relationship Mr. Dyer and the child between Mr. Dyer and the child of his girlfriend. The testimony would have directly opened the door for testimony from the alleged victim that Mr. Dyer had also molested the child of his girlfriend, and the testimony from the alleged victim that Mr. Dyer had molested her in a tent on a separate occasion. Paragraph 20, Charles Dyer response. The alleged victim already testified by way of forensic interview, bar number 1, Exhibit 8, that she never saw me do anything inappropriate with my girlfriend's daughter, and she did testify to molestation in a tent on pages 99 and 100 of her testimony. And Mr. Hoch forgets that he asked the child on page 102 of Cross about the incident in the tent. The alleged victim testified that she never said anything to anyone about a tent for 3 years after the supposed incident, until one day before her testimony on the third trial while being interviewed by the ADA. This conveniently tied up a hole in the prosecutor's case. Once again, Mr. Hoch is either lying to you or confused about the case. Paragraph 21, Albert Hoch. The testimony would also have opened the door to allow the introduction of telephone calls from the jail involving Mr. Dyer, discussions of these complaints, and the manipulative and threatening conversations between Mr. Dyer and his girlfriend. Mr. Dyer's girlfriend went as far to say that she would call the FBI and the DA to tell them what Mr. Dyer did to her daughter. Charles Dyer's response to paragraph 21. Mr. Hoch is clearly lying here, and I challenge him to produce evidence. I know what Mr. Hoch is referring to, and it is not a jail call, nor is it allowable in court because of the source of the conversation and the fact that it is multiple conversations spliced to appear like one. Mr. Hoch denied me access to this very recording for about 5 months before trial. To this day, he still has not presented it, regardless of his repeatedly telling me I could hear it the next time he came. Paragraph 22, Albert Hoch. By not opening the door to these topics, I was able to keep these jailhouse telephone calls containing prejudicial information and comments from Mr. Dyer, as well as the additional complaints of sexual abuse from the jury during this trial. Okay, that's paragraph 22. Charles Dyer's response. Mr. Hoch knows the call he refers to in 21 was not a jailhouse call, nor was it allowable in court. There were no additional complaints of sexual abuse. Paragraph 23, Albert Hoch. Other information, such as the evidence from the computer hard drive, was either irrelevant or opened the doors to such prejudicial information as additional allegations of molestation, attempts to conceal evidence, Mr. Dyer's membership in a self-styled militia, or the gun charges. Once again, the Dyer family fails to tell you that I was successful in getting the weapons charges severed from this trial and was able to keep all of that prejudicial information from the jury. Paragraph 23, Charles Dyer's response. Mr. Hoch is lying once again, as paragraph A completely demonstrates relevance, and nothing on the computer contained any information concerning additional allegations of molestation or attempts to conceal evidence, and I challenge Mr. Hoch to produce evidence otherwise. Also, nothing on the computer opened evidence of membership in any militia or gun charges. Also, nothing on the computer opened evidence of membership in a militia or gun charges, as the hard drive was presented at the first trial and none of this was mentioned. And Mr. Hoch claims that the Dyer family fails to tell you that Mr. Hoch was successful in getting the weapons charges severed from the trial. They didn't tell you that because it is both irrelevant to the initial grievance and a lie. I present bar number 6 to you that clearly shows the motion to sever filed over a year before Mr. Hoch was hired by me. This motion was granted and severed on the first trial. Additionally, bar number 7 shows the judge ruled all previous motions in effect from the first trial, April 2011, on page 7, lines 10 through 14. So mentioning this as some great achievement my family failed to mention is just sad and a desperate attempt to give a facade of effectiveness. Beyond these clear misstatements of facts, I also am not, nor ever have been, a member of a militia. I had plans of volunteering training to militia members, but was arrested before doing so. Beyond this, I provided tactical training to airsoft teams in Southern California. Paragraph 24, Albert Hoch. The Dyer family complains about decisions not to offer information from the internet or individuals affiliated with self-styled militia groups to support a conspiracy theory involving government persecution of Mr. Dyer. Paragraph 24, response by Charles Dyer. To my knowledge, the Dyer family never attempted to produce evidence from individuals affiliated with the militia to support a conspiracy theory. If it was asked, it was done without my knowledge, and I challenge Mr. Hoch to present proof of this. Paragraph 25. Albert Hoch. Some of the information was not offered because it was irrelevant and came from sources which could not be qualified. Some of the information was not offered because it also would have violated orders of the trial court. All of the information was not offered because it was irrelevant to the child's testimony, and it opened the door to A, impeachment through information provided by Mr. Dyer to the office of the district attorney, and or B, to impeachment through information provided by the FBI to the office of district attorney. Charles Dyer's response, paragraph 25. Mr. Hoch is again vague, and I am unable to respond as no specifics or proof is presented. Albert Hoch, paragraph 26. The Dyer family also wanted to use information posted on the internet in a so-called Hinkie report, which included unsubstantiated generalized allegations of misconduct within the Stevens County government as well as within other state and federal governments. Charles Dyer's response to 26. I know that information was leaked. I know that information was leaked to the Hinkie report. Hinkie meter by my supporters. They had no information that my family didn't give them. Mr. Hoch is too vague and presents no proof for me to respond to. Paragraph 27, Albert Hoch. Opening these doors would have permitted the office of the district attorney to introduce to the jury items of evidence such as Mr. Dyer's online video depicting Dyer holding high-powered weapons and stating anti-government rhetoric while declaring himself to be the July 4th patriot, and all of the evidence concerning Mr. Dyer's flight to avoid prosecution as well as an instruction on flight as evidence of guilt. During this video, Mr. Dyer also wears a mask and a Marine Corps uniform while stating anti-government rhetoric. Charles Dyer responds to paragraph 27. Mr. Hoch claims that doors would have permitted videos of me to be presented to the jury of me holding high-powered weapons and stating anti-government rhetoric while declaring myself to be the July 4th patriot. Mr. Hoch lies again and further shows his unwillingness to confirm things he reads or hears. The lie is the statement of weapons and rhetoric. The lie is the statement of weapons and rhetoric. Not once have I held a high-powered weapon and stated anti-government rhetoric. There is one video about 3 minutes long with me and 2 friends demonstrating a contact drill and no other videos with me holding rifles. Other videos of me training airsoft teams, I am holding a toy rifle and never speak anti-government rhetoric while holding one. The anti-government rhetoric are political rallies or videos of me quoting founding fathers or altering founding father quotes to present day use. I served 8 years in the Marine Corps and 1 year on a sheriff's department. I am anything but anti-government. I am anti-corruption. If Mr. Hoch believes repeating speeches of our founding fathers, quoting them, or speaking about the Constitution is anti-government, then I'll wear it as a badge of honor, but I refute his claims altogether. In regards to me declaring myself the July 4th patriot, Mr. Hoch is simply ignorant of the truth, but of no fault of his own. July 4 Patriot is simply my YouTube account name. When I didn't use my real name, people called me by my YouTube name. This account is still active to confirm and investigate Mr. Hoch's claims. I never declared myself the July 4th Patriot. Additionally, I have never made threats or encouraged violence, and these videos were up prior to the first trial and never came close to being admitted into evidence, as I am simply a political speaker, and what I've said is as irrelevant to my case as this paragraph is to my grievance. All right. Let's go to paragraph 28 by Albert Hoch. All of the benefit of the severance would have been lost if the Dyers family legal strategies had been followed, and profoundly prejudicial and extraordinarily inflammatory information would have been submitted to the jury. Charles Dyer responds to paragraph 28. The Dyer family's legal strategies are irrelevant, as their opinion has nothing to do with me or my strategic decisions. My legal strategy was to present the evidence that did not result in a conviction and further it with the evidence in paragraph A. As explained in 27, my political views are irrelevant and were not allowed in the first trial. The judge didn't even allow the prosecutor to ask if I or my family are NRA members. Mr. Hoch agreed to my strategy and did the opposite without ever consulting me. Paragraph 29, Albert Hoch. Through my tactical decisions, I was able to keep all of this information from the jury, including the flight information, the multi-state manhunt, the return to jail, and the prosecutors were unable to get a flight instruction. Through my tactical decisions, I was able to keep all of the weapons, militia, and hate crime evidence from the jury. Charles Dyer responds to paragraph 29. I cannot confirm Mr. Hoch's claims. Mr. Hoch informed me that the manhunt was done without DOJ approval and began 2 days before I even missed my court date and was therefore illegal. He also said the prosecution didn't want to mention the flight instruction because the evidence in paragraph 5 clearly proved fear and not guilt and opened doors the prosecution didn't want to open. Mr. Hoch's tactical decisions did not keep evidence of weapons and militia out of the trial. My proof is that none of it came out during the first trial, and further, I challenge Mr. Hoch to show specifics of how the hard drive would open doors to these issues. Finally, Mr. Hoch is flatly lying about hate crime evidence, as none exist, and if it does, he decided not to present it to me or even notify me of it. I challenge Mr. Hoch to present it. Paragraph 30, Albert Hoch. Several times during the trial, when Mr. Dyer's mother complained about a trial decision or wanted to present some irrelevant argument or wanted me to violate orders of the court, Mr. Dyer simply stated, ignore her, since he was advised about the reasoning involved and agreed with the decisions. Paragraph 30. Indeed, I did tell Mr. Hoch to ignore her because I was his client, not my mother or anyone else. This is my life, my case, and my business. Trial decisions are not up to my mother or Mr. Hoch, but are for my final decision. Mr. Hoch is under the impression that by hiring him, he owns my case and can do what he pleases and not include me whatsoever. And then Charles cites Grant versus State, 2004, Oklahoma, CR 2485, PED 178-182 refutes this, and Lott versus State, 2004, OKCR.27-164-98, page 3D, 318, 357, confirms my right to be involved in my case as it affects my life. Okay, paragraph 31, Albert Hoch. The biggest single philosophical difference of opinion between my office and all of the Dyer family, except the defendant himself, involved the role that the self-styled militias should play in the trial. During the first trial, the militia members made themselves obvious through distinctive armbands while hovering around the courthouse. In between the trials, they interneted extensively. Charles Dyer, paragraph 31. To my knowledge, the Dyer family did not want the militia to play any role in my trial, and as he clearly acknowledges, I didn't either, which is the only opinion that matters, so this paragraph is completely irrelevant. I challenge Mr. Hoch to present specifics of his once again vague statements. Mr. Hoch's statement that the militia members made themselves obvious through distinctive armbands while hovering around the courthouse at my first trial is a complete and brazen lie to the Oklahoma bar in a shameless attempt to say the militia was involved in my trial. Not one militia member or non-militia member for that fact hovered around the courthouse nor wore armbands of any kind. No militia members at all, to my knowledge, attended any part of my trial, either inside nor outside of the courthouse. On the last day of the trial, Rick Light arrived after dark and stayed in the parking lot across the street until jury deliberation was over. Upon request, I can provide affidavits from Rick Light, Robin Starsky, Jan Dyer, Amy Dark, Larry Dark, David Hammond, Amanda Monsalve, and Monica Freeman to confirm this, as they were all present. Rick Light was the only militia member to ever come to any of my trials. The only time the militia came to the courthouse was for a court hearing. That was not for me. And what relevance is it for anything that people use the internet between my trials? I'm sure millions of people internet daily. So what? This statement leaves me dumbfounded. Paragraph 32, Albert Hoch. All of the groups that the Dyer family was affiliated with are heavily monitored by the Federal Bureau of Investigation. During the discovery process, the prosecutors and the agents from the FBI provided me with information that could be introduced during a trial if certain topics were opened. Immediately prior to the trial, threats to the courthouse itself, the prosecutors, the judge, potential jurors, law enforcement personnel, and others, including me, were communicated by militia members. This resulted in heightened security within the courthouse and would have been unbelievably prejudicial if linked to Mr. Dyer. Through the tactical decisions made during trial, all of this information was kept from the jury. Charles Dyer responds to 32. Once again, Mr. Hoch is vague about information that could be introduced. I challenge him to provide specifics and proof. Also, I challenge Mr. Hoch to provide proof of threats. I will acknowledge the threat against Mr. Hoch by a Cecil Medina, who is not a militia member and is actually anti-militia, and will label it bar number 32. I challenge Mr. Hoch to present proof how any of this could be linked to me. I am not a member of a militia. I was unaware of any threats had even been made. I'm positive that no one I know made threats because they work closely with law enforcement, and none of this has anything to do with me or my case. To suggest this could be brought up is preposterous. Okay, paragraph 33, Albert Hoch. The security arrangements included having perimeters manned by law enforcement officers established around the courthouse and neighborhood, FBI surveillance photographs of numerous militia people, and at one point I was advised that SWAT personnel had been stationed on the roof of the courthouse for protection. Charles Dyer responds to paragraph 33. What is the relevance of surveillance of militia people by law enforcement? The only militia person that came to my trial ever was Rick Light. If SWAT were mounted on the roof and heavy surveillance was present over one man, nearly 60 years old, it would be an amusing overkill of manpower. Once again, I challenge Mr. Hoch to present evidence, and I offer the previously mentioned witnesses at my trials, and additionally will add Nancy Genovese and Lisa Mize for affidavits on this issue upon request. Paragraph 34, Albert Hoch. Other evidentiary decisions were made by the trial court and are now on appeal. For example, the Dyer family complains about evidence of possible abuse of the minor child by other members of her family or other individuals. The trial court refused to allow this testimony from any witness even after I had one of the family members brought from the ODOC on a writ to testify. The trial court ruled that these were unsubstantiated allegations. These rulings are now on appeal to the Oklahoma Court of Criminal Appeals. Charles Dyer, response, paragraph 34, I agree. Albert Hoch, paragraph 35. Miscellaneous personal attacks. I am not a drinking buddy with the district attorney nor any of his assistants. At the time of this trial, the district attorney was Jason Hicks, who was in his first term of office after having been in private practice specializing in civil cases. The first assistant district attorney was also new to Stevens County, having served in the eastern part of the state. You know what? I'm going to do 35 and 36 together because they cross the front and back of the page. In the eastern part of the state of Oklahoma previously, all of the other assistant district attorneys involved in the prosecution of Mr. Dyer were also new to the office. I had never tried a case with or against any of these attorneys prior to Mr. Hicks taking office. I had no personal relationship of any kind with any of these attorneys and would not have stated otherwise to the Dyer family, nor was I dating any member of their staff. My girlfriend was a court reporter in a private practice who previously worked for an Oklahoma County District Judge. Okay, that was 35 and 36. Okay, Charles Dyer's response. I cannot comment on Mr. Hoch being drinking buddies with the DA. If he is, he never mentioned it to me that I can recall. In regards to the dating relationship, my words were poorly chosen and were not meant as a personal attack. Mr. Hoch did certainly tell me that he had a relationship outside of work with someone in the DA's office, and I was fortunate that she couldn't be used in the case as it was a conflict of interest. If I am incorrect in my details, I gladly submit to Mr. Hoch's clarification. But if it is said that this conversation never happened, it's a lie, as he mentioned it a couple of times. To investigate this, Mr. Hoch logged in when he visited me at Stevens County Jail. Simply review my calls, and then he gives a phone number, 580-252-7266, or on the next couple of days after his log-in date. Details on these conversations are on those calls. The only reason I brought this up in the grievance was because it struck me as a possible reason to throw my case and remove evidence to ensure failure of direct appeal. Let's go on to paragraph 37. Albert Hoch. Further, I am a diabetic and cannot drink alcoholic beverages. Feel free to contact any member of the Office of the District Attorney for any district in Oklahoma. I have had cases, including jury trials, in 75 of the 77 counties in the state of Oklahoma. The attorneys and staff members will confirm that do not drink or date members of their staff. Okay, Charles Dyer's response to paragraph 37. I have no knowledge of Mr. Hoch's drinking habits. However, since he denies drinking, I have included bar number 9 concerning Mr. Hoch drinking alcohol during my trial, diabetic or not. Okay, paragraph number 38, Albert Hoch. Finally, parts of my family live in Southern California in the high desert where it is convenient to meet me in Las Vegas, Nevada, together with other members of my family which live elsewhere. Any discussion about meetings in Las Vegas would be about my family gatherings or about the annual public defender retreat and seminar which I try to attend or about checking on my cases. I may have referred to local counsel there. There would never have been discussions about work in Las Vegas, nor would there have been any discussions about continuances relating to work in Las Vegas. The Dyer family knew my schedule when they hired me. Paragraph 38, Charles Dyer responds, I know nothing of this. Paragraph 39, Albert Hoch. With regards to the complaints concerning the polygraph procedures, because Mr. Dyer was incarcerated, the polygraph which I scheduled had to be performed in the county jail or the courthouse proper. The district judge refused permission to have the polygraph performed in the jail or the courthouse. The district judge was visibly upset at our attempt at a polygraph and stopped the procedure. The Dyer family was informed about all aspects of these decisions. Mr. Dyer indicated to me that he did not wish to pursue orders from an appellate court concerning a polygraph because he understood that the results were not admissible for any purpose. He may not have He may not have passed anyway, and he would rather have the impression with the court and anyone that might hear about the denial, including potential jurors, that law enforcement was afraid he could pass. Okay, that was paragraph 39. Charles Dyer responds, Mr. Hoch shoulders no fault that the polygraph was stopped. Mr. Hoch is blameless in this and truly attempted to have a polygraph done, though I am unsure why this is mentioned. Paragraph 40. Okay, paragraph 40, Albert Hoch. Miss Dyer had previously filed complaints with the Oklahoma Bar Association against the Assistant District Attorney prosecuting Mr. Dyer. Miss Dyer alleged that the ADA had divulged information about sexual abuse allegations involving another Dyer family member, when the truth of the matter was that no one had been aware of allegations until Miss Dyer brought them up. Okay, let's read. Charles Dyer responds to paragraph 40. I know nothing of this. Any evidence that surfaces will be labeled bar number 10. Paragraph 41. Albert Hoch. You might also be able to obtain information from the Office of Professional Responsibility of the United States Department of Justice. In addition to complaining to you on the internet and anyone else who will listen, the Dyer family filed a complaint with them on the FBI agents involved in the case. Praise God. Charles Dyer response number 41. I know nothing of this. Any evidence confirming or denying it will be labeled bar number 11. Albert Hoch, paragraph 42. Everything possible was done to provide Mr. Dyer with an effective defense. Any limitations on the defense were imposed by the conduct of Mr. Dyer and his family. Charles Dyer responds to 42. To say that everything was done to provide effective defense is laughable. Were this not such a serious matter, I have already presented my case and evidence on the contrary, and presented evidence that Mr. Hoch has in the past called multiple people liars concerning events, including a pastor. I know Mr. Hoch will lie to protect himself, and have presented proof of not only this, but that he lied to you in an ill-thought-out attempt to paint a seriously inaccurate picture of me. He provides no proof of a single thing he stated in his reply, and remained overly vague through it all. Paragraph 43. Albert Hoch. I was successful in keeping out evidence of other sexual molestations of both the alleged victim, in this case, and another minor child. Evidence of flight to avoid prosecution, a multi-state manhunt, weapons charges, and hate crimes. I was successful in keeping out a flight instruction. I was successful in keeping out jailhouse telephone calls and other prejudicial out-of-court conduct and statements of Mr. Dyer. Charles Dyer responds to paragraph 43. There were no other minor child alleged victims. There was no hate crime evidence. The weapons charges were already severed. Mr. Hoch refers to phone calls that never happened, and he never allowed me access to these calls in order to tell him what and where these calls originated from. Paragraph 44, Albert Hoch. No lawyer could keep out the vivid testimony of the victim, nor the physical corroboration of the molestation from the physicians. Charles Dyer responds to that, paragraph 44. The, quote, vivid testimony of the victim is very uncertain and contradicted. Partially explained in paragraph 12. The corroboration Mr. Hoch refers to is not corroboration, and it should frighten any client of his to know Mr. Hoch can't even distinguish what corroboration is. Corroborating evidence is supplementary evidence which tends to connect the defendant with the commission of the crime charged. There were not multiple physicians, as Mr. Hoch claims. There was only one, and by his own testimony, it is not even definitive that sexual abuse even occurred, let alone I were the author of it. let alone that I were the author of it if it had. On base of this paragraph, perhaps Mr. Hoch is correct that no lawyer could keep this evidence out. To say one way or the other would be speculation on my part. Mr. Hammond was unable as well. Paragraph 45, Albert Hoch. At the end of the day, in words of the infamous Charles Dyer, part of me kicks myself in the ass for not taking that 2.5-year plea bargain. See attached copy of handwritten letter from Mr. Dyer posted on the internet. Mr. Dyer listened to his family and followed their advice instead of mine. This occurred even after his sister reviewed the tape of the forensic interview of the minor child and said, quote, something did happen to that baby. I told him that one jury had already said 25 years to serve, and that jurors usually believed children like his daughter. Paragraph 45, response by Charles Dyer. Quote, part of me kicks myself in the ass for not taking a 2.5-year plea bargain. Show me a man that receives a 30-year sentence when he could be home next Christmas and says he doesn't see 2.5 years as a lesser of two evils in hindsight, and I'll show you a man that's a liar. In the words of the infamous Charles Dyer, Mr. Hoch childishly shows his levity to this grievance as much as he did in my trial. This is nothing but a lack of professionalism at its finest. I did not listen to my family and did not fail to follow any of Mr. Hoch's advice. The simple facts are that Mr. Hoch didn't give advice, but rather accepted stacks of papers I wrote him without ever reading them, never presented evidence to me, greeted my ideas and strategy with a smile and a nodding head, agreed to represent me as I asked, and agreed to present the evidence already presented at my first trial, and then without doing even a fraction of what he promised, and with over 10 witnesses uncalled, I hear the defense rest. I was infuriated, and the only answer I got was that he got the evidence and what we needed. When I threatened to disrupt the court and tell the judge we weren't resting, Mr. Hoch told me to calm down, and if it didn't work, I could bring it up on appeal. I expressed my anger at Mr. Hoch on the pretrial sentencing statement just days later, bar number 12, if available. Mr. Hoch's completely removing me from the decisions of my case, placating me with everything I presented to him, being totally unfamiliar with my case, withholding evidence from me, not allowing access to evidence I requested, and hijacking my case as if he owned it, effectively allowed me to jump from a plane after he shredded my parachute to pieces. Paragraph 46, Albert Hoch. I have included multiple documents for your perusal. You may also find more information about Mr. Dyer, Miss Dyer, and their complaints if you Google search July 4th Patriot. Please feel free to contact me if you need any additional information or documents. Charles Dyer responds to paragraph 46. I have reviewed the documents that Mr. Hoch sent, and I have numbered them 1 through 4 and returned them with my reply. 1. This is a letter to Rick Light. I do not understand the evidentiary value of this. 2. There is some random website I know nothing about with a blog posted by a Drake whom I do not know, announcing a radio show Rick Light and my mother did 4 months after conviction. He incorrectly wrote my name as the July 4th Patriot, which explains why Mr. Hoch also stated this. He obviously gets his information from random websites, of which are often riddled with incorrect information. 3. This is a blog posted by a Walter Huey, whom I have no idea who he is, on a website I've never heard of. It contains a question and answer segment I wrote online about 3 years ago in response to a flood of interrogatives from people. Once again, I fail to see the relevance of anything concerning my case or grievance. 4. This is a blog by Terry Bonzio, whom I'm told walks across the country for military veterans on a website I never heard of. Of these 15 pages, 3 concern me. Of these 3, none contain anything I wrote or said. He did get my YouTube name closer than the other, July 4 Patriot. Of these 3 pages, only one has anything on it linked to something I did. On page 3, the bottom picture is a still shot I took and posted online 4 years ago. Of these 30 pages, only 6 contain anything I wrote, and these were done years before Hoch was hired, except the letter. I'm at a loss to understand what, if any, is relevant to. At least no more relevant than if I referred to Mr. Hoch as the horrible attorney on a website, circusclowns.com, and then tried to claim he is a circus clown that declares himself the horrible attorney. It's all just as ridiculous and irrelevant to any issue whatever. And with such horrible representation and acts by the justice system, does Mr. Hoch not expect my family and I to complain to anyone who will listen? In my initial grievance, I did not discuss even a minute amount of the information Mr. Hoch elicited by his reply. Mr. Hoch is a Marine, and I did not wish to slander him in any way. My family and I had been unable to reach him or have mail replied to, and it's not unreasonable to want to find out why. Mr. Hoch removed evidence before it was given to OIDS. I would not have gone outside of this realm due to our mutual brotherhood. However, Mr. Hoch has acted dishonorably by lying and misstating multiple issues. As this conduct is unethical, I now wish to increase the scope of my complaint to include the following. 1. Mr. Hoch lied to the bar that he advised me to take a plea deal, paragraph 10. 2. That Mr. Hoch provided untrue information to the bar in regards to paragraph 16 unless he is able to provide and prove specifics. Number 3. Mr. Hoch provided untrue information to the bar in regards to paragraph 17 unless he is able to provide and prove specifics. Number 4. Mr. Hoch provided untrue information to the bar in regards to FBI interviews concerning additional molestation unless he can provide proof, paragraph 18. Number 5. Mr. Hoch lied about the victim possibly testifying to molestation of my girlfriend's daughter and keeping testimony about a tent from being presented to the jury in his bar reply, paragraph 20. Number 6. Mr. Hoch provided untrue information to the bar about a jail call that does not exist unless he can produce it, paragraph 21. Number 7. Mr. Hoch lied about the relevance of evidence in regards to the hard drive in his reply to the bar in paragraph 23. Number 8. Mr. Hoch provided untrue information to the bar concerning additional allegations of molestation unless he can produce evidence, paragraph 23. Number 9. Mr. Hoch provided untrue information to the bar concerning my attempts to conceal evidence unless he can produce evidence, paragraph 23. Number 10. Mr. Hoch provided untrue information to the bar concerning the Dyer family, attempting to produce evidence from the militia to support a conspiracy theory, paragraph 24. Number 11. Mr. Hoch lied to the bar by stating that videos exist of me holding high-powered weapons and he kept these from being seen by the jury, paragraph 27. Number 12. Mr. Hoch lied to the bar about the hard drive evidence opening doors to mentioning the militia in paragraph 29. Number 13. Mr. Hoch provided untrue statements to the bar concerning his tactical decisions keeping out evidence of weapons unless he provides proof, paragraph 29. Number 14. Mr. Hoch lied about the hate crime evidence to the bar. This evidence doesn't exist, paragraph 29. Number 15. Mr. Hoch lied to the bar in regards to the militia members hovering around the courthouse while wearing armbands during my first trial, paragraph 31. Number 16. I am suspicious that Mr. Hoch is being untruthful about threats to the judges and prosecutors, and proof should be presented, paragraph 32. Number 17, I am suspicious that Mr. Hoch is being untruthful about information the FBI presented him, and proof should be presented, paragraph 32. 18, Mr. Hoch provided untrue statements to the bar by saying prospective jury members were threatened unless he provides proof, paragraph 32. Number 19, Mr. Hoch provided untrue statements to the bar by suggesting any threats could have been linked to me when he knows otherwise, paragraph 32. Number 20, Mr. Hoch's statement to the bar in paragraph 33 is untrue unless he can provide proof. Number 21, Mr. Hoch lied to the bar about never drinking alcoholic beverages, paragraph 37. Number 22, Mr. Hoch provided untrue statements to the bar about being responsible for the severing of the weapons charges in paragraph 23. Number 23, Mr. Hoch did not fully inform me of the evidence and facts in violation of of ABA Part 5 and Standard 4 through 5.1a. 24. Mr. Hoch came nowhere near being thorough and prepared for my case in violation of O.5, Title 5, Chapter 1, APP 3A, Rule 1.1. Number 25. If Mr. Hoch's decisions were that of strategy, it should have been explained to me. This is a violation of O.5, Title 5, Chapter 1, APP 3-A, Rule 1.4b, and discussed in comments 1 and 5. 26. Mr. Hoch hijacked my defense as explained in paragraph 30. 27. Mr. Hoch did not maintain communication with me concerning representation, as he was always too busy to give me specifics of anything the DA claimed concerning new evidence, violating OS Title 5, Chapter 1, APP 3A. 28. Mr. Hoch did not act with diligence in representing me, violating O.5, Title 5, Chapter 1, APP 3A, Rule 1.3. 29. Mr. Hoch did not keep me informed, violating ABA Part 5, Standard 4-3, 8A, and O.5, Title 5, Chapter 1, APP 3A, 1.2A, 1.4A1, and 1.4A2. I thank you greatly for your time and assistance, Mr. Wallace. If you need any transcript of the trials, minus judges' chambers, follow-up evidence, or anything else that may assist you, please call that phone number. I think it's Miss Dyer's phone number. Or send an email to missquilt42@yahoo.com, and every measure will be made to assist. Sincerely, Charles A. Dyer, Semper Fi. I'll just stick in my own commentary at the end of this. What they did to Charles is extremely similar to what they have done to Russell Landers and Schaefer Cox. And it appears that Albert Hoch was either intimidated or bought off and somehow lost his way. It's hard to say if he is just a cowardly, incompetent lawyer or if he was somehow influenced by outside factors. But Albert Hoch did not provide a good, effective counsel and defense for Charles Dyer. And Charles Dyer should be set free. And there's no doubt in my mind that Albert Hoch, the Bible calls out one profession by name, and it's lawyers. And you know that these lawyers will lie to protect themselves, and they will sell their clients down the river. I pray that you keep Charles Dyer in your prayers. Write him a letter. Do not forsake this man. Do not abandon this man. And let's pray to God and ask what we can do to get Charles Dyer out of prison. And may not only that, but all of these wicked people who have lied about Charles and did not give him effective assistance of counsel and are now resorting to lies, and especially Valerie Dyer, that the evidence that was held from the computer, we know that Valerie Dyer was involved in coaching the daughter, and that she should be held accountable for what she has done and the false conviction of Charles Dyer. Thank you for your time.